Thabang Boer is a senior legal researcher at Advocacy Group, Section 27, and she joins us via Skype. Thabang, thank you so much for joining us. Now, is this exclusion fair?
So first and foremost, I think it's very difficult for us to draw a conclusion that the exclusion is unfair, because we need to look at specifically what the language policy says and whether the language policy is consistent with national policy and the Constitution, because those two documents draw what each school's policy ought to be. If it's not in line with the national norms and standards for language and it's not in line with the Constitution, then we can say that it amounts to unreasonable exclusion.
You have people who have labelled this as clearly a racist issue. Is it a racist issue, or, as you say, it can't really be labelled until the language policy is looked at and taken to task? What's your take on this?
I think it's always important to consider the role that language has always played in South Africa's education system. If you think about it, during the apartheid period, language was used as one of the barriers to education. And by using Afrikaans, for example, the youth stood up and said we would not be taught in this language because it's something that we do not subscribe to, something we don't understand, and something that limits our right to access education. And so, historically speaking, language has always been one of those barriers and has a relation to race. And so if you draw it in this context, it's important to remember that if in face value it looks like it's language, but the group that's predominantly affected and excluded by such a language is black, then you could draw the inference that there is a racial discrimination. But we are always obviously not easy to draw those relations, but to say that it's important to think about the role that language has always played in the history of schooling, and where there's those links, it's easy to draw those links. So it's not difficult to conclude that this policy in its application affects predominantly black students and therefore amounts to some sort of discrimination on the basis of race.
Now, let's look at the North Gauteng's judgment, the High Court judgment by Judge Bill Prinsloo, who basically has made a judgment on this. And what's your view on this, and the fact that government or the MEC has come out and said they will take this further on appeal?
We unfortunately haven't been able to read the judgment. Since it's released, it hasn't been typed, and so it's not publicly available yet. And so we can't make a definitive opinion on the piece. But what we can say is the courts have dealt with language policies in the past and came up with what are the considerations that should be looked at when a school and a department is fighting over a language policy. And so what courts have said, and this is in the Ermelo case at the constitutional court level, is that the department has to look at the access to that school, whether there's access to that school or other public schools in the area. They have to look at the school's enrollment and its ability to take on learners. They have to look at what the language policy adopted by the SGB is and whether it's consistent with national policy. They have to consider whether there are reasonable alternatives for learners, and they also have to make sure that they come up with something that's feasible, fair, and takes into account racial discriminatory laws that used to affect in the past, because they have a duty to redress. And so looking at all of these factors is what a court needs to do in able to come out and say whether the implementation of a policy is fair or not fair.
Have you been able to find out whether the school does have capacity, as opposed to the argument in court that it does not have capacity to accommodate these pupils? Just referring back to the clip that we had earlier, one of the parents saying that they literally live 2 streets away from the school, but in terms of, you know, a student walking to the school as opposed to a student traveling on with a public transport having to be dropped off, does the school have capacity to take on additional pupils?
A capacity is something that can best be determined between the school and the department, because you have to look at what the infrastructure looks like, whether there are teachers that are able to teach, whether there's sufficient furniture and all of that, and actually how many places the school has. I think what's more confusing about this case is that at one stage the principals had indicated that they had space and then later said they didn't have space. And so I think a proper investigation needs to take place at the department level to determine what is the capacity of the school and how much they can take on.
Thabang, you mentioned that a higher court can decide after looking at the language policy, and as you mentioned just now, that in terms of capacity and the fact that they have come out before and said they do have capacity and then changed to say they don't have capacity. Can a higher court, for instance, the Kong Court in particular, change this decision by the North Gauteng High Court with regards to this particular school going forward?
The quick answer is yes. So the department can appeal to the Supreme Court of Appeal, or they can petition the Constitutional Court directly to review the decision of the High Court. From where we sit and from the little that we know about the case, we think that the case so far goes against our jurisprudence. So previous cases have said even if the department acts in a very heavy-handed way, they may set aside the instruction by the district or the department, but still the court would still say to the school, reconsider your policies, because your policies affect not only the learners that are in your school, but also people in your community. And it's important that in the policy making process that the school governing body must ensure that both the interests of the community is met. So those are all the learners of the community, including those black learners.
How do you think, how best do you think the education system can avoid such repeats of what we've been seeing over the past couple of days?
I think one of the good things that we are looking forward to is that the department has put in place the Basic Education Amendment Laws Act, which seeks to amend both the South African Schools Act and the Employment of Educators Act in order to bring them in line. Like I've said, there's been a long list of cases where school governing bodies and the Department of Education have come to head. And so what this policy or what this law is going to do is try and give very specific powers to the HOD to be able to say to a school, your policy is discriminatory, it unduly restricts access for learners, or is unreasonable, and either take away the powers of the SGB or say to them, go and relook at your policy and make sure that it's in line with the Constitution and the national policy. And so I think it's important for Bella to come through so that we can have definitive law that says the buck ultimately lies with the department to ensure that all learners receive a quality education.
Thabang, thank you so much for joining us. We'll have to leave it there for now. That was Thabang Boe, a senior legal researcher at Advocacy Group Section 27, and she was joining us via Skype.